right, so, Mr. Johnson, we already kind of went through this, but in 24, hold on, let me get it pulled up right. 24 DCCR 2095, I'm in the wrong place. Sorry, you guys, I was on the wrong day looking at that other stuff. Give me just a second. And there was already a rejection done in the aggravated robbery for a 40-year term, and that has now changed to a 15-year offer. So, Mr. Johnson, in cause number 24, DCCR 2095, we've gone through this before. You're charged with a first-degree felony offense of aggravated robbery from September 7th of 2024. The indictment alleges you were previously convicted of robbery March 9th of 2015. What that means, if you go to trial and are found guilty, are there other priors as well?
There are priors, but not the enhanced.
So this wouldn't, he wouldn't be habitual,
He's not,
he would
he's
be
not a repeat offender. I noticed that Mr. Wilkerson checked the box for habitual. It actually should be a repeat.
first degree enhanced.
Enhanced, that's right.
So what that means is that if you go to trial and you're found guilty in that case, and if that prior offense is true, you would be considered enhanced for punishment, which means the minimum would be 15 years up to 99 years or life. Do you understand?
Judge, give me just 1 second.
Yeah. Anna, I don't know how, this is not erasing. I've pressed. Now it did, just because I said that. Let me double check that there weren't. Because in December of 2024, there was something filed that is the state's notice of intent to use prior convictions to enhanced to habitual. We've got the robbery conviction from March 9th of 2015 and an evading arrest or detention with previous convictions. So that's the misdemeanor that was enhanced. Do you think that that's a state jail felony, right? An evading arrest that's enhanced is a state jail.
I looked at that. I think I even talked to Corey even about it. I don't think we'll get there with that.
Okay, all right, so that's what it looks like was filed, and so it looks like, in fact, if those are the two prior offenses, it would be a first-degree enhanced punishment, again, with a minimum of 15 years up to 99 years or life. Do you understand? And then, in cause number 25, DCCR 1626, hold on a second, let me find it. 1626.
I think the habitual offender box is checked on that one too.
Yeah,
It should just be a repeat offender.
I could have sworn there was more than one greater than state jail. So that's why I'm double checking.
Yeah, no, go ahead. I'll give you a minute to do that. I'm just looking at what was filed, and it looks like the second one was, in fact, just a state jail.
Possession of state jail, evading prior state jail.
You want me to roll that one?
Right here.
Oh, it's not there, okay, that's it.
Let's see. That one.
It's not, it's gonna go, no, it's gonna be. Yeah, that's it, they work. That's why I was wanting to talk about that.
Sorry, Your Honor.
As best you can.
No, right here.
I might be mistaken. I only see in the original indictment on the aggravated robbery that one felony that is above the state jail level. So if I'm wrong, then that's better for my client. I just I'm
the court in Needham was of the opinion that we could not use a evading arrest that had been enhanced to further enhance this.
I think that sounds correct to me as well. And so, in the clause number 25, DCCR 1626, you're charged with unlawful possession of a firearm by a felon. And that's from October 9th of 2025. And what that means, it has the same prior offense conviction listed as well. And what that means in that case is, again, the habitual, it's not habitual, it would be enhanced first degree, which means the minimum punishment would be 15 years up to 99 years or life in prison. Do you understand?
Yes, ma'am.
No, I'm just, do you
No, I'll say yes,
under,
ma'am.
the question is, do you understand?
Yes, ma'am, I say yes, ma'am.
Okay. And so I have, in both of these cases, new plea bargain rejections that you've signed with Mr. Wilkerson's that shows that the district attorney's office has made offers, if you wanted to enter plea of guilty, for 15 years in each case to run concurrently. You have every right to reject that and have a jury decide. And so is that what you want to do, is reject that and go to trial?
Just before you answer that, I just want to make sure, maybe I misheard on the unlawful possession of a firearm with a felon, or by a felon. My understanding is it starts out as a third-degree felony and is enhanced
To a second. I messed that up as
So
well.
it'd be 2 to
Misspoke.
20.
So it would be 2 to 20.
Sorry. All right, let's get on the same page. I'm so sorry. You're correct. So that was, we all messed up on that one. And now okay. Unlawful possession of a firearm by a felon, third-degree felony. The prior conviction is for robbery from March 9th of 2015. If you go to trial on the unlawful possession of a firearm and you're found guilty and that prior conviction is true, it would only enhance to a second-degree felony, which is between 2 years and up to 20 years in prison. Do you understand that?
Yes, ma'am.
Okay, so the possible punishment ranges on each of these: on the unlawful possession of a firearm by a felon, 2 to 20; on the aggravated robbery, 15 to 99. You understand? The offer is 15 years on each of them to run at the same time concurrently. Again, you have every right to reject that. Is that what you want to do?
On the unlawful carry, I didn't, but I didn't want to take the aggravated.
I
outside.
don't, so here's the
Yes,
thing.
ma'am. Yes, ma'am.
We're gonna go forward on whichever, we'll set them both for trial,
Yes, ma'am.
and it will be the state's election on which one to go forward on first. If they elect to go on that unlawful possession, that's what we'll go forward on. We'll get the other one taken care of as quickly as possible also. I just wanna make sure you don't wanna take this deal today. Okay, then
Judge.
we'll get the cases set for trial on the next available trial docket.
I do want to mention, just for record purposes, again, we do have that motion for speedy trial pending in that older aggravated robbery charge. So if the state does elect to proceed on the new indictment, we'll be asking for a dismissal of the aggravated robbery based on the fact that they decided to try a new case as opposed to granting the speedy trial request of the defendant.
Well, I'm gonna get them both set as speedy as possible. Obviously, you guys know that there's nothing lagging over here as far as getting trials set. If something happens on that date and you think legally you have something to file, we'll take care of any legal issues when that comes up. All right? All right, you can go back with the bailiff.
Thank you.
Thank you, Your Honor.
Thank you so much. No.
messing everything
Don't
up.
touch it
Why?
because they're electronic. And we'll fix it from over here.
Oh, it's electronic?
All right. Please, ma'am. It's fine. Mr. Nichols, would you like to be on the screen?
I don't care, Judge. This is where I am every day.
All right. Okay, sir, are you Terry Rose?
Yes, ma'am.
Mr. Burbank, will your client waive the formal reading of the indictment?
You will.
Mr. Rose, in cause number 24, DCCR 1369, you're charged with the first-degree felony offense of murder from July 9th of 1999, and how do you plead to that charge?
Guilty?
Are you pleading guilty freely and voluntarily?
Yes.
And are you pleading guilty because you did what they charged you with?
Sort of. Yes. Yes. Okay.
No,
Yeah.
we're not playing, hold on.
Yes.
Listen to my question. You answer my question. Mr. Burbank, I'm not questioning you. Did you do what they charged you with in cause number 24, DCCR 1369?
Yes.
And again, are you pleading guilty freely and voluntarily?
Yes, ma'am.
All right. I have here on the tablet some documents that have your signature on them that the state has marked as Exhibit Number 1. Before you signed these, did you go over them with Mr. Burbank?
Okay. Oh, did I?
Did you go over them with him? The documents that
Oh,
you
the
signed on the
documents,
tablet?
Yes, he explained them and I signed.
And do you
I did.
fully understand them?
Kind of, I'm not a law person, but
What do you not understand, Mr. Rose?
most of it, but it's okay.
No, it's not okay.
Oh. I read-
Mr. Rose,
Yes, ma'am.
this is not a game.
I'm not playing a game.
We're about to go to trial next week, okay? I don't have to take this plea agreement. We can go to trial. We can let a jury decide. If you didn't do it, if you sort of did it, or whatever you're trying to say, we're not playing games. There's too many people involved in this situation that have waited too long for this day and for next week. We've got a jury coming. There's no reason for us to be doing this deal today unless you actually did it and take full responsibility. Because if you don't, then what I don't want to happen is when I get the pre-sentence report, and if you don't take responsibility, then I'm going to reject the plea agreement and we're going to be right back here. So I'm inclined right now, based on this, to probably reject, and let's go ahead and go to trial next week is what I'm thinking. So,
Your Honor, my understanding is that he intends to present some evidence at sentencing that he feels may lend to a either sudden passion charge or some mitigation. I think that's where that hesitancy is coming in, Your Honor.
okay. But so is it just going to be for mitigation under the first degree felony? It's
Yeah.
not some sentencing trying to get a sudden passion ruling?
No, it's he's pleading to murder and within the code, then I can argue, or we can argue for sudden passion after the conviction of murder.
That's what I'm asking though, is so what I'm saying is, when we come back for sentencing, you're going to be arguing a legal issue, not just for me to sentence at the cap of 40, you're going to be asking for me to consider
Something
making a
less.
finding, not just say, listen, not just something less. Are you asking me to make a finding of sudden passion, which would reduce it to a second degree felony is my question.
If you deem that it was appropriate.
But that's what you're going to be asking for on sentencing. I think that's what a jury should do. And that's your understanding?
Yes, Your Honor, I have no problem with that. I don't expect that. I expect to present evidence that'll make the court's decision easier.
So it'll be a whole sentencing hearing, trial type for sentencing alone. If you're going that far, we'll have several witnesses, I'm assuming.
I will be calling several witnesses, yes, Your Honor.
Mr. Burbank, I guess you would have to at least call someone for the sudden passion, your client, or,
Either that, or it could be outlined in the PSI report, Judge.
no, if we're going to do it at a hearing, I would need actual testimony legally in order to, if whether it was a jury or the court, in order to make a finding of that. So that'll be up to you guys. Okay. So let's go back then to the paperwork, Mr. Rose. Tell me anything that you went over that you don't understand in this paperwork.
Well, I just didn't read all of it. I do understand what it means, or what it's gonna mean.
Okay, so do you understand that the agreement that you've reached is for a cap of 40 years in prison?
Yes, ma'am.
And what that means is you're leaving your punishment up to me. I can give you 40 years, I can give you less. It depends on all the information that's brought to me at that sentencing hearing, including any witnesses and a pre-sentence report. You obviously have the right to let a jury determine two things, if you're guilty or not. And then if they decide if you're guilty, you could leave your punishment up to that jury. If we go forward this way, you're waiving that right. And is that what you want to do?
Yes, ma'am.
Okay. Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation exclusion from admission to the country, or denial of naturalization under federal law?
Yes, but I'm born here.
I'm required to ask everyone that.
Oh, well, okay.
And I just want to make sure, I know, Mr. Nichols, you're obviously in contact with the family.
Yes, Your Honor.
Do they know that this is taking place
I
this
informed
morning?
them shortly, once I found out this was taking place.
Okay, and they are ready and prepared and
Yes, sir.
want to go forward with this morning?
Yes, sir.
Okay. State tenders number 1.
Just for the record, Judge, because I want to make sure it's clear. I have gone over it and explained all the paperwork to Mr. Rose. Mr. Rose, I have answered all your questions, correct? Yes. You have asked me questions in reference to taking this plea, correct? Yes, sir. And I have satisfactorily answered all the documentations that you signed here today to your satisfaction. Yes, sir. No one is making you plead. You're doing this freely and voluntarily. No, I'm doing this voluntarily.
Thank you, Mr. Burbank.
And I have no objections, States One.
Thank you. States 1 is admitted. Is there any evidence that Mr. Rose is not competent?
No, Your Honor.
And actually, with regard to that, I do believe that
He was evaluated previously, Your Honor.
So I will take judicial notice of the court's file, and Mr. Rose was previously evaluated for competency to stand trial. That was done by Dr. Grapan. We received that report back in May of this year with the finding that Mr. Rose was competent to stand trial. Any other issues with regard to competency?
No, Your Honor, I did that out of precaution. I requested it. I did that out of precaution, not that I saw anything, but because of the length of the case, the nature of the case, I want to explore every possible defense that Mr. Rose might have had.
All right, then I will, again, I know I already said that, but I will find Mr. Rose competent and that he entered his pleas freely and voluntarily. And so at this time, Mr. Rose, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case, a short reset, to get the probation department to do a pre-sentence report. We'll come back for sentencing. I think it's looking at like the afternoon of the 16th. We'll have at least 3 hours or so for anybody to put on any evidence that you want to with regard to sentencing. And the pre-sentence report, probation officers has let us know that they will be willing to get that done quickly. Get with you, Mr. Burbank.
And just like that, the guilty plea is accepted, but the story isn't over. Sentencing is still ahead, and that's where the defense plans to present mitigation evidence, including arguments related to sudden passion. The conviction is in place, but the final chapter, how much time will actually be imposed, has yet to be written.